Hi, everybody. Thank you so much for joining us today on a Friday afternoon, St. Patrick's Day. My name is Kevin Kampschror. I am a partner for workers' compensation at Shook & Stone, and we are really excited for everybody to be joining us today. We have 1 hour, so there's a lot to talk about with workers' compensation. I could probably talk for 5 or 6 hours. But we've narrowed it down to the topics that we think that we hear the most about, and the topics that we will think would be of the most interest to you. So again, thank you for being here for our first webinar, When to Hire a Workers' Compensation Lawyer. So who are we? Okay, who is Shook & Stone? You can see right there on the screen, there's John Shook and Leonard Stone. They've been in business since 1997. We've represented thousands of clients in all types of cases. And I'm about to get into the different areas of practice. We consider ourselves a full service disability and injury law firm. Okay, and what does that mean? That means we cover personal injury, we cover car accidents, we cover workers' compensation and Social Security disability. So it's easy to see why the multi-award winning law firm Shook & Stone should be your first choice, because we do it all. Now, here's our wonderful team. Okay, so although Shook & Stone are lawyers, and I am one of them, we would be nothing without our class act staff. And that staff is very robust, and we work as a team. And so it's important for the audience to know that, yes, we are lawyers. We also have this robust staff that help us every day with the thousands of clients that we are able to service. And we are able to service the thousands of clients because of our robust staff as well. All right, we're going to get right into the material of workers' compensation. As you can see from the slide that's up, there is one chance to recover in workers' compensation in Nevada. Now, it's important to note that workers' compensation is state specific. So I'm only speaking about Nevada. You will find that laws are different from state to state. Okay, so I'm only covering Nevada. There are some similarities, but I'm only talking about claims actually that originate here in Nevada. And when I talk about the one chance to recover, okay, that's where we talk about something called exclusive remedy. Okay, well, what does exclusive remedy means? Again, you can kind of describe it as you have one bite at the apple. All right, if you get injured on the job, you must file a workers' compensation claim in Nevada. That is your remedy. Okay, and in fact, injured workers do what we call renunciate. That's what the law says, their common law rights and remedies. Okay, what does that mean? So unlike a car accident that is a different set of laws, when you file a workers' compensation claim, you are giving up your rights at common law, which again would be things like negligence, pain and suffering, which is a big one. Okay, so there are some big differences. So it is so key to file the workers' compensation claim, because you will not be able to get those same benefits that I'm going to go into today if you don't actually file that claim. Okay, now, with all law, there are exceptions. So certainly there are exceptions, okay, in regards to filing a workers' compensation claim, i.e. the one bite at the apple. And the exceptions, okay, are number 2, where what is a possible third-party claim, okay? Now, a third-party claim, what that means, okay, and I'm going to share with you an example that kind of will illustrate what I mean by that. Meaning is, if you filed the work comp claim, is there any other way to recover besides the workers' compensation claim? Now, after I've just said, hey, you've got one bite at the apple, well, there are some exceptions, which makes it so important to come to a full service disability and injury law firm that handles everything, and not just workers' compensation, not just car accidents, that we do it all. Okay, and that's what Shook & Stone does provide. Now, A kind of an example of a possible third-party claim, which can illustrate a potential other avenue of recovery, is what I call the Domino's Pizza delivery case, where if you are a delivery driver and you are out there and you're working and you're delivering pizzas and you're sitting at that stoplight, and all of a sudden, unbeknownst to you, Susie Smith comes plowing into the back end of your car and rear ends you, okay? That is what we call a third-party claim. So number one, you would file a workers' compensation claim for your injuries on the job. And then number two, there would be a possible third-party claim there. So that's the easiest example to look at. There are others, okay? But all the more reason that you engage with a workers' compensation attorney, because we will be able to screen those things for you, okay? Really, the general public is not equipped to be able to determine where are all of the avenues of recovery. And if you just go to a lawyer that only does personal injury, they may miss the workers' compensation claim altogether, okay? And it can also work in the other direction. If the workers' compensation attorney doesn't do personal injury, then perhaps they are missing these opportunities of these possible third-party claims. So when I talk about the legal screening needed, that's what I refer to as the full service disability law firm and the full service injury firm, because we do all of that for you. So if you come in, and all of our consultations are free of charge, you come in for a consultation and you bring us a legal problem and an injury, we screen it to make sure we have everything there for you and that we can obtain all kinds of recovery depending upon if the facts and the circumstances and the law fit your case. Okay, and we do all of that. It is really important to note that workers' compensation is very, very specialized. So there's not a lot of attorneys that necessarily even practice workers' compensation in Nevada. And I will tell you that many of the just straight personal injury attorneys do not actually handle workers' compensation claims. So again, with such a specialized area of law, it is in your best interest to come to a law firm that actually does it all. Now, like I said, the laws are different, okay? So when I say that personal injury attorneys don't, some of them that don't do workers' compensation, well, if the laws are different, okay, then their mistakes can be made. Lack of experience certainly plays a factor in that. And I will say, unfortunately, that people will come to us sometimes, 4, 5, 6 months into their workers' compensation claim, where they may already have a personal injury attorney and mistakes have been made because that personal injury attorney didn't know what they were doing in a work comp claim. And there's a lot of things that have to work in concert together if you have a work comp claim and you're that Domino's Pizza delivery driver and someone rear ends you and you have a possible third-party claim. Okay, now moving on with the one chance to recover. Nevada, okay, is very specific. This form that you see on your screen is the foundation of all claims, okay, literally. So if you don't fill out this form, there is no claim. And as it says, it's completed by you, okay? The top part, okay, you see the black line that goes through that separates the form. The top part is actually filled out by you. The bottom part is what the doctor that you're sent to fills out. So without this form, there is no claim. And it's a deal breaker, which I'm going to talk about later. There's a couple of deal breakers in work comp that we're going to talk about, this being one of them. Okay, you must have this C4 form or there is no claim. And this is specific to Nevada. And now some adjusters I've heard adjusters say before that, other states don't have these requirements and what have you. And okay, great. But if you're in Nevada, this form is required and you will not be able to obtain benefits without this form. Okay. Now, what happens is you'll fill out your part at the first medical visit after you've seen the first visit you've seen the medical provider. A lot of claims in Nevada, you start out at a Concentra type of clinic. Okay, you certainly don't stay there. I'm going to get into how you can end up there if you don't have representation, and stay there if you don't have representation. But that's generally where these forms are filled out at a clinic like a Concentra. Certainly, if there's trauma or you get sent to the emergency room, they're also filled out there. Important to know that workers' compensation only deals within a specific panel of doctors. And what that means is that not every doctor can treat you when you filed a work comp claim. It has to be very, very specific, and they actually have to be on this panel. And there's a specific fee schedule, all of those things. And so you can't go use your own doctor or the doctor that's your family doctor or even a specialist that you generally use. It does need to be on the specific panel of doctors. And this is just something that you will not know, and something I will talk about later about. We do know these doctors. And we have access to the panel and have been doing this since 1997. And I'll talk about that more in a minute. But this form, very important, deal breaker if you don't actually file this form. Okay, who qualifies for workers' compensation? Now, this slide says that workers' compensation is designed to get employees swift and medical financial attention for job-related injuries or illnesses while keeping employee and employer from wrangling expensively in court. The law actually says that the purpose of the Nevada industrial insurance system, okay, is swift and efficient administration of benefits. Now, I have a smirk on my face because these claims get extremely expensive, and they do pit employee and employer at times against each other. And certainly there's one other key involved, which is an insurance company. Okay, employers have to have workers' compensation insurance. Generally, what will happen is they'll have a third-party administrator, okay, which is just really, it was no difference than an insurance company, but they will have them administering their claims. And so it does get expensive because I litigate things against these insurance companies daily for things that I shouldn't be litigating because they're either not doing their job, not responding, not providing benefits that you're clearly entitled to, okay? It happens every day. And so it is designed to do all of this, okay? But trust me, you can't do it on your own. If you want swift medical and financial attention and swift and efficient administration of workers' compensation benefits, you will need a lawyer. I wish I could paint a brighter picture of workers' compensation in Nevada, but it is a broken system. And so all the more reason not to take these people on yourself. They are not here for you, okay? We are here for you. Now, I'm going to go through these bullet points here, okay? Because an injured worker, okay, you have to be classified as a, using air quotes for employee, okay? And here's the law. When you see NRS, okay, that's a law. I'm not going to go into the whole depth of the law. I don't want to put everybody to sleep, but the definition of employee in the workers' compensation context is legally defined, okay? So you actually do have to be an employee, all right? Now you think, well, that can, is easy. Well, sure. If you're working at the MGM and you're actually are an employee and you're a car dealer or you're a valet parker, you're an employee of someone. You're on a construction site, you're likely an employee of someone. So the definition of an employee, you think, well, how would that come up? And that's our next bullet point. Okay, now, employers must carry workers' compensation insurance in Nevada. They do not have a choice. Okay, but where some of them, okay, and generally when I'm speaking generally here, is that where we see employers try to get around this, okay, is they determine that they don't have employees, okay? They have, everybody's an independent contractor, all right? Now, your classic independent contractor, I like to use an example as like a real estate agent, okay? Because generally you're working for yourself and you're doing your own thing and you're your own boss and you aren't considered an employee. Now, not in all circumstances, but just generally, okay? But the employer, and we usually see this with the smaller kind of, I'll refer to them as mom and pop employers, may try to get around this. Why? I can only speculate that they don't want to pay for workers' compensation insurance, but are they able to classify their workers, okay, that they're not employees, they're actually independent contractors, okay? And they can even come up with this really beautiful agreement between the worker and themselves that says, oh yeah, right here, you're an independent contractor and we're not responsible and what have you. They can just not have an agreement and just tell people you're an independent contractor, okay? But it's according to the law. And there's actually a test set out from the Nevada Supreme Court that has all of these factors that will determine whether or not you are legally an employee and whether or not you then have to cover them under workers' compensation, okay? Agreements between people mean nothing. I've been to court many times where they've come to me and they've said, well, you know, I'm an independent contractor. They've been injured on the job. They're an independent contractor and here's the agreement. And that agreement is invalid because it's against the law, okay? Because you run the test on it and you find that, okay, you may think these people are independent contractors, but they are actually employees, okay? Now, the fines and the penalties for employers not having workers' compensation insurance is hefty. And usually well, not usually, always, if you're alleging that an employer doesn't have workers' compensation insurance, they will investigate and even shut them down. Luckily, you think, well, what if I run into that situation? What if I'm in a situation where they think I'm an independent contractor and I'm really an employee and they don't have workers' compensation insurance and, you know, one of my fingers is missing, okay, from being cut off of a table saw. Well, luckily, the state of Nevada has set up an uninsured fund, okay, as well as an insurance company, or like I said before, a third-party administrator that actually administers those claims in the event that it is found out that your employer does not have workers' compensation insurance. So you're not left hanging out to dry. Now, how do you go about that? We help with things like that. I wish I would say it's uncommon to run into this, but we do run into it, and we assist in getting that process going. So not only is the employer, of course, held accountable that they need workers' compensation insurance from the regulation end, not from our end, but most importantly, that you get the benefits that you're entitled to because you didn't know that when you started working there, that all of this was going to happen. So again, being an employee is important and crucial, and that definition is crucial in meeting the test. The injury must be work-related. You think, of course it must be. Okay, now that means it must arise out of and be in the course and scope of employment. And there's the other law that says NRS, okay, and that law says exactly what I just talked about. Now, when we talk about work-related, okay, the way that the law works is you can't just simply be at work and get injured and an automatic path to an accepted workers' compensation claim, okay? So when it's work-related and arising out of and in the course and scope of employment, I'm gonna give some examples that would mean that it would not be work-related, even though you were at work, okay? I'll give you two examples. All right. The first one, say you are in a casino and you're a slot host and you are walking across the carpet, and for whatever reason, your pant leg is a little too short or too long or what have you, and you kind of trip on your own foot and you go down, okay? And you break your kneecap, okay? Based on those circumstances, it likely would not be a valid workers' compensation claim. You certainly could file, but that is the type of scenario that would likely get denied. And the reason is that you just happen to be there, okay? We all as humans put ourselves at risk for everyday activities, okay? Which I will show you with the next example too. But if you trip on your own foot, okay, that doesn't mean that your employer has to then cover your injuries, okay? That's an example that it doesn't arise out of employment, okay? Because there was nothing that the employer did. There was no risk that the employer created that caused your injury. And that is an element that is required, okay? The second example is, say we're standing right here, or sitting right here as I am, and I have my pen, and I drop the pen, okay, even if the employer bought the pen, and I bend over and I pick up the pen, and oh, I tweaked my back, okay? That is another example that is not work-related, okay? Because the way that the law works is everybody bends and twists and does all of those things in normal life, okay? So the employer is not then tasked with covering that type of work comp claim, all right? Now, when your claim gets denied, or if it gets denied, but in many cases when it gets denied, a lot of the denial letters will cite this particular law, okay? Now, whether the claim is, the denial is valid or not, people come to me with denied claims all the time and I get them accepted, okay? Because it's about the law. And trust me, adjusters can't be trusted with applying facts to law, trust me. But when it talks about, when they cite these statutes, as well as different cases that have been decided in Nevada Supreme Court, you're reading in this going, okay, well, what does this mean? I see that my claim is denied, but this is the foundation of them denying your claim, okay? Certainly if you have a denied claim, which is the theme of this whole webinar, you definitely need to seek out a work comp attorney to screen all of this for you, because you don't want to be making factual and legal conclusions without consulting someone. And that's just, of course, in general, but especially if the claim is denied, and especially when this is the standard, okay? The next important part about qualifying is that you must meet reporting deadlines, okay? I'm gonna go into the specifics of these in a later slide, but like I said, there's 2 deal breakers. You have to report it to your employer within 7 days, and you must file that C form within 90, okay? Now, there's some variations there on what does that look like, which I'm gonna get to in a minute. But you have to meet those reporting deadlines. Those are really kind of what we would call in law bright line rules, okay? If you haven't notified your employer in 7 days, or if you have not filed the claim, you haven't filled out that C4 in 90, you really don't have a chance, okay? Because Nevada does not recognize equity, okay, in regards to, well, I know you were late, or I know you didn't do this, but let's make you whole by doing all that. We don't have that, okay? Now, certainly, if you are in a coma, all right, and are not able, okay, to fill out the C4 in 90 days or things like that, there are some really, really specific dramatic exceptions, okay? But they are really, really far and few between. And so it is really important that you get injured on the job, that you notify your employer within 7 days. A supervisor, you don't just want to, hey, coworker, got injured. It's got to be someone that actually has some sort of supervisory role, all right? And you've got to file that C4 form, okay? Next is, okay, the burden, okay, meaning what do you have to prove, okay? All of it, okay, with two exceptions, are all on the injured worker, all right? Now, everyone has seen TV, okay, where criminal law, you hear beyond a reasonable doubt, okay? That's the legal standard for criminal law, right? And so that's all or nothing, okay? That's not us. Right below that, you have clear and convincing evidence, which I'm just going to describe as kind of 2/3. That's not us. And you have the final legal burden, which is what we call preponderance of the evidence, which I have PPEVI, all right? That's us, all right? And what that means is that as the injured worker, or me as your attorney, I have to prove my case by preponderance of the evidence every time, except for two exceptions, okay? Every time. What preponderance of the evidence looks like is you have a teeter-totter, and the teeter-totter just tips right over the 50% mark. So 50.00001. That's preponderance of the evidence, okay? It can't be balanced. The teeter-totter can't be balanced. It's got to just be shifted. That is the legal burden that you can visualize, okay? Now, the two exceptions, if you have pre-existing conditions, okay, which many people have, and that is one of the most litigated topics we have in workers' compensation. And quite frankly, claims get shut down all the time because of pre-existing conditions. And it's because they're not even applying the law correctly. Adjusters are leading doctors into these responses, and doctors don't know what they're doing in regards to law. They're there to practice medicine, all right? But we litigate pre-existing conditions all the time. But if you have pre-existing conditions, that burden, so one of the examples, shifts to the employer/insurer for them to prove, okay, that your pre-existing conditions actually were the main factor and the work injury wasn't what we call substantial contributing cause. Now, this is all like a bunch of legal jargon, but you can see how complicated it gets. And everybody has pre-existing conditions. So if you do, okay, no matter how slight, yet another reason to seek counsel, because that is just a heavily contested and highly litigated issue. The second topic, which I'm going to get into in detail later, is if you get fired, okay, with an open workers' comp claim, all right, gross misconduct, the term is gross misconduct. That burden also shifts to the employer, that they have to prove that this injury had nothing to do with it, okay? Nothing to do with them terminating you, and it was because of something called gross misconduct, which I'm gonna talk about. Another heavily litigated topic and another area of law and workers' compensation that you just do not want to take on yourself. And that's one of the most popular, one of the most popular questions we get about being fired during a work comp claim, or what does your employer think? Like all of these types of things. What are they going to think when I hire a lawyer? Okay, so we're going to get into those things and address those questions. Okay, now this list is not what we call exhaustive. There are other things, okay, but what is considered an accident or injury? Similarly to the definition employee, there are legal definitions of what an accident is and what an injury is, okay? But here's some examples. So you have a slip and fall, all right? That's pretty self-explanatory. Slip and falls are dangerous, okay? They include your neck, a lot of times your spine, your lower back, shoulders, knees, because newsflash, when you have a slip and fall, you're not expecting it, okay? And so, it just really, really can mess up your body. We also find with slip and falls that there's potential third-party claims. Remember when I talked about in the beginning, is there another avenue of recovery? Slip and falls, you may find that, but again, all the more reason to come to Shook and Stone so we can screen that for you and determine, is there another avenue besides the workers' compensation claim, okay? Construction accidents, this is a biggie, okay? Yes, it's including falls, and it's including, crush injuries and, injuries of falling in holes. There's equipment that knocks you over. There's, it is just a very physical job. Nevada, we have heat. There's conditions like that. It's just so key to know that also the construction accidents, it can involve faulty equipment, okay? Again, a possible third-party claim. Now, again, we would screen that there certainly are some criteria, but it is, not uncommon if you're on a construction zone and you're using heavy equipment or any type of equipment, that equipment fails, okay? Or something happens to, the equipment caused that injury in some way, all right? The next one, the repetitive motion accidents. So this is what I will just kind of refer to as the carpal tunnel type of injury that can be connected to work. There's some different reporting requirements and timeframes, which I'm going to get into in another slide, about repetitive motion, and it's called they lump in repetitive motion and occupational illness. Okay, well, of course, the biggie occupational illness, COVID. Okay, but inhalation could be considered occupational illness. So that's another category. Okay, hearing and vision loss. Okay, joint muscle damage. Those, the latter, the joint muscle damage are, some of the most common. Hearing and vision loss, again, going back to the construction site, we've represented a lot of clients that have had, metal and things go into their eyes. They've had to have extensive eye surgeries, lost their eye. So, these are just some examples. Of course, my next bullet point, I've already covered the occupational illnesses and exposures and inhalation. Inhalation can be scary because depending, it can really infect other areas of your body. Okay. So for example, if you have an inhalation injury and they're giving you steroids, well, that can mess with your joints, and then all of a sudden your joints are being affected by, something like that. Well, that's a natural and probable consequence of work comp. And so that will be covered under the claim. Factory accidents. Now, including digit loss and amputations, those are devastating. Okay. Digit loss and amputations are some of the most emotional cases. They are some of the most life-changing cases, and we handle many of them. Unfortunately, maybe too many, but it does happen. And these, more catastrophic claims do happen. Okay. Workplace violence. Okay. Those poor flight attendants, workplace violence, it happens. Okay. Let me tell you something. I recently litigated a case where, there was workplace violence, and the insurance company tried to get out of it saying, well, we didn't control that. It wasn't our problem. That's not how the law works. Okay. Or who started it? Well, this isn't criminal law. We're not, but so workplace violence, hopefully you're not in a place where there's workplace violence, but that is a work comp claim. Okay. But again, hopefully that's not happening. Traumatic brain injuries, another devastating injury that just impacts your entire life. And the disturbing thing about TBIs, so traumatic brain injuries, are, again, they don't necessarily show you all of the symptoms in the beginning. And so I have seen clients with TBIs that just progressively get worse. Okay. And of course, the insurance company is like, oh, this isn't how he was back here. Well, this is how he is now. And medical records may not be reflective of that, but I was sitting there talking to the person. And so I was like, we have a problem here. So those are scary. All right. And if anyone has ever dealt with anyone with a TBI, I mean, it is life changing. And if you can't get the proper intervention, and that prognosis just goes down, you have a real catastrophic problem on your hands. Now, wrongful death, unfortunately, people do die at work. Okay. There are a specific set of they're called death benefits. And these cases are sad because you are, representing, their dependents who have just lost a family member. Well, they've lost a husband, they've lost a dad. And so, we have had our fair share. And so, real important that in the event that there's a death on the job site, that you seek out proper counsel immediately. There is recovery for dependents. Okay. Now, I talked about the 2 deal breakers here, so we're going to kind of dive a little bit more into them. I'm going to give you some examples of what I've seen. So, timeframes, or SOL, which stands for statute of limitations. Okay. So notify your employer in 7 days, okay? And when I say, what does that look like in real life? I'm gonna share a couple of examples, okay? So, the most common is, say you have a guest room attendant at the Luxor, okay? I'm just picking these properties out of nowhere. So, and they're making a bed and they tweak their back, and they go and notify their supervisor that they actually tweaked their back. It's done right away. Then they fill out the appropriate paperwork at the hotel, and then the hotel transport them to a Concentra type of clinic to begin the claim. That's where they do the C4, okay? That happens frequently, all right? Where there's no question that there was notice in 7 days, and the employer isn't saying they weren't noticed in 7 days, okay? But as you can imagine, it doesn't always look like that, okay? Now, you have 7 days to report this. So I don't know how many hearings I've sat in where the defense attorney in there from the insurance company and all their glory is in there going, well, they reported for 6 days. Guess what, folks? You have 7, okay? And, I'm gonna use the construction field. This happens all the time. Well, I don't know about you, but I don't go to the doctor unless I absolutely have to, okay? And little tweaks and, pinches and things like that happen. Okay, okay, let's take some ibuprofen. It's gonna go away. I've got 2 days off. All of that happens all the time with construction workers, okay? That is why you have 7 days to report it. But every day that you don't report it, they're gonna make you to look like you're a liar. Okay, and that you actually really injured yourself. How do we know you didn't injure yourself at home? All right, you didn't, okay? But it happens frequently where you get injured maybe at the tail end of your work week. You just think, well, whatever, you don't say anything, you're gonna go home for your 2 days. And then you find out when you're home for those 2 days that, oh, yeah, no, I'm injured, I need to see the doctor. So you notify your employer on Monday, and then all of a sudden the claim gets denied. Okay, you reported it in 7 days, but they're like, well, we can't confirm it really happened at work. Okay, that happens all the time. All right. Now, I have had cases where the employer has claimed that they were not aware of the work injury. Okay, and one of the cases I remember, I said, really? Because it was an apartment complex. And the ambulance and the fire department, okay, because it was a person that worked like in the main clubhouse, okay, ambulance and the fire department come, and you didn't know that, take the person to the hospital, okay, you didn't know that happened, okay, yes, true story. Okay, so yeah, okay, no, the person didn't come and say, I'm injured, but who called 911? Okay, I literally was arguing this, okay, one, all right? But that can happen. No, we didn't know. Really? You didn't notice that those kind of flashing lights and the sirens and all that coming onto the property? The other thing that we use frequently when employer claims they don't know is you have text messages. I mean, electronic messaging now is huge. And so a lot of times we'll have the client bring in text messages with, Supervisor Dan or Office Manager Sheila or whoever it is. And we can utilize those texts to show, yeah, you did know, okay? And if you're saying you didn't know, yeah, here they are. Here's the dates. Now, rules of evidence for any attorneys in the field, they are relaxed, what we call relaxed rules of evidence. That doesn't mean no rules of evidence, okay? But it's very easy to get your client to come in and authenticate those texts and say, yes, that's me, and this is when I sent them. You don't have to go and subpoena records from Sprint. You don't need to hire an expert, anything like that. But these are real life situations, okay, where employer is saying they didn't know and we prove them wrong, okay? Now, the filing the claim of the 90 days of the C4, I've gone into this, but so I will tell you there is one little wrinkle with the C4 and the 90 days. When I just told you about the notice requirement, and I gave you the example of the fire department and the ambulance and the text messages, the C4 doesn't work that way. Okay, the employer can know that there was an injury. They can send you to the hospital. Okay, they can take you to the hospital. They can provide care, all of that. If you don't file a C4, game over. Okay, even if the employer is aware that the injury occurred. Okay, that issue has been decided by the Nevada Supreme Court. Okay, I don't like that, but okay. Literally. So you've got to file that claim no matter what. No matter who knows, who doesn't, anything like that, you've got to do it in 90 days. Both of these things are deal breakers. Okay, occupational diseases like the carpal tunnel syndrome. Look, what happens, your notice requirement, the minute a doctor says, yep, you've got carpal tunnel and it's work related, that's when your 7 days starts. That's when your 90 starts. Okay, so it's different than the actual injury. There's a knowledge element. Okay. All right, the most important part, why hire a work comp lawyer? Who are you suing? No one, okay? It is a claim, it's not a lawsuit. For all intents and purposes, it looks like a lawsuit, and you have a lawyer and we go to court and all that. By the way, generally when you hire a lawyer, you don't go to court at all, unless you have to testify, okay? We do it all for you. But you're suing no one, okay? So you think, well, God, what if my employer finds out I hired a lawyer? Don't tell them, okay? If you go and say, well, my lawyer says this, we advise you not to do that, okay? So you don't tell the employer because the employer probably will not find out. I would tell you most employers don't hold it against you. We'll talk about in the event that they do what the penalty could possibly be, okay? But you're not suing anyone ever, all right? Now, insurance is not there to give you legal advice. So, which goes on to the next one about general public doesn't know if the case is going well or not. So people sometimes come in and they want to sign up with us, and for whatever reason they don't. It's that, oh, well, things are going okay. How would you know? Okay, you have no idea if things are going okay. You have no idea who you're seeing. You have no idea, you have no idea. And you're relying on the adjuster to kind of tell you. The adjuster is not a lawyer. The adjuster will not give you legal advice, and the adjuster will let you sink your own case, period. I see it all the time. They will trick you. They will lie to you, okay? I see it all the time. So that is all the more reason when you were injured on the job to seek out a work comp attorney, okay? Now, I talked about the multiple ways to recover, all right? You don't want to leave any money on the table, okay? Work comp is designed to treat you and get you back to work. It's not there to make you rich. So if anyone says that they got millions from a work comp claim in Nevada, nope, they didn't, okay? But anyway, so there's could be multiple ways to recover. The preferred doctor network, look, I talked about the panel of doctors, okay? Not only does Shook and Stone, do we have our, preferred doctors that we refer to you per body part, and we have several, okay, that we trust, okay, that we know are going to be straight up and they're going to take care of people, and they are going to have a good relationship and what have you. Okay, there's also doctors we know not to use, okay? Why? In my view, these doctors are very insurance prone, okay? If you're not represented and the adjuster says, hey, go see this doctor, who do you think they're sending you to see, okay? Ask yourself that question, all right? Now we have the 90-day rule. 90 days from the date of injury, you get to pick your own specialist. If you have multiple body parts, you get to pick multiple specialists, okay? Insurance companies will not guide you through that. They will not. I've had people that are stuck in Concentra, okay, for 8 months. All right. And we're like, well, so when they come and see us, they're like, oh, any reason why you're Concentra? Well, they didn't tell me that I could, do all of this. This is kind of what the adjuster said. So it happens. Next part of the wages. Okay. Is your average monthly wage correct? Okay. Now, what is that? There's certain criteria that the insurance company and the employer must compute your average monthly wage, and they must use the highest of all of the calculations. And depending upon how long you've worked there, okay, you are entitled to a year wage long calculation if you work there for a year, and an 84-day. If you work there less than a year, okay, there's some different criteria, but the wage calculation drives the value of your case. So the wage calculation is probably one of the most important things. And if you come to an attorney and you come to Shook and Stone, we audit those, okay, and make sure that that wage calculation is the highest it can be, okay, because that means more high value of a case, and that means more money in your pocket for the disability evaluation that comes at the end of the case. All right, we talked about pre-existing conditions and how all of that works. Look, it's complicated and everybody has them, all right? And doctors, insurance companies, all of that, they will just shut down your case based upon pre-existing conditions, based upon their misreading of the law and misapplication of the law. So you have to litigate that. And lastly, the rateable impairment, okay? You don't know. If I asked you right now if there's any injured workers in the audience right now, I said, are you stable and rateable? You're not, you probably won't know what that means, all right? Even if the doctor says you're not stable and rateable, does that mean we can still move forward and get you to a rating? We can, okay? And again, all the more reason that you hire an attorney, because we will not leave any benefits on the table. Our job is just to drive the truck and just blast it through and get everything that we can, okay? You won't be able to do that. You're not equipped for it. And again, adjusters will just let you just drift on out without on your little raft, and oh, there goes the oar. Okay, that's what they do. All right, lastly, can I be fired? All right. Sure. Okay. I say yes and no because Nevada for employment is an at-will state. Okay, so they can fire anybody for anything they want at any time. They don't have to explain anything. Certainly, I'm not an employment attorney, so I'm not getting into any of that. But yeah, I mean, they can. All right. You do have protections under the claim when you have work restrictions. Okay, this is when we're talking about the gross misconduct standard. Okay, is that you can, if say you have work restrictions, which many do, okay, they're temporary because eventually you're going to get back to work and what have you. If you have temporary work restrictions and the employer says, you know what, let's just cut ties with this person. They filed a claim, screw them, okay? Or let's just cut ties with this person because we think we're going to save money on our premiums and all these fallacies, okay? What happens is they have to, the only way they can get rid of you without continuing to have to pay you while you're not working there is if they fire you for gross misconduct, okay? Now, there is no definition for gross misconduct. All we have is legislative history of examples of what gross misconduct is, okay? So what we do know gross misconduct is, and you can think, oh, this sounds, like gross misconduct, physical violence at work, okay? Although I talked about it being a compensable claim, if you get into it with your coworker and you get into a fist fight, you probably will be fired, and that's probably gross misconduct, okay? Drugs and alcohol at work. Okay. If you're snorting, crystal meth in the bathroom, then you probably are going to get fired. Okay. And that's going to probably be considered gross misconduct. Okay. But those are really the only two examples. All right. As you can imagine, though, does the employer, when they're looking to get rid of you or and really in concert with the insurance company, I will tell you, employers oftentimes aren't even involved in this. It's the insurance company saying, hey, you call this gross misconduct, you don't have to pay them. Okay. I mean, I've had situations where employers, come to testify at hearings. I'm like, so what's your, gross misconduct? They're like, I don't know what that is. Really? Because that's what you terminated your own employee for. Who told you about that? The adjuster. True story. Okay. So they will allege anything is gross misconduct. Okay. Attendance, odor. I mean, these are literal examples I've had. All kinds of things that, poor performance, non-compliance with rules, all these things that they certainly can fire you for, okay? But usually do not rise to the level of gross misconduct. So all the more reason to hire a work comp attorney, because we know, I mean, I litigate these types of cases all the time, and we prevail a lot, because this is their burden to prove that they fired you for gross misconduct and it had nothing to do with a work injury. Okay. Now, as you can imagine, employers don't be like, well, we actually really let them go, because of the work injury and all that. That never is said. Okay. And you never have like the smoking gun or the Few Good Men, that movie, A Few Good Men moment. Okay. Where, someone's on the, and you like get it out of them that they're like, you fired them for all that. That doesn't exist. At least I've never had that. They just say, oh no, it's this or what have you. And they try to allege that everything is gross misconduct. So you have to be able to have the tools in your arsenal to combat that. And people just don't. Okay. And this is a topic that if they fire you and they're going to stop paying you and you have work restrictions, you are in a real bind. Okay. Because you can't just go get another job. You've got work restrictions and a doctor may or may not release you. So here you are sitting at home with your family, with your bills that you still need to pay, without an income. Okay. So it's a real problem. Okay. We are, what's our time? We want to do a Q&A. Okay. I'm at 4:52. Let me see in regards to, let me see questions that are in here. Okay. What if your workplace is a hazard due to smoking or exhaust leading to lung cancer? Okay, well, I mean, that's complicated. That's layers upon layers, okay? Certainly a doctor would actually have to say to a reasonable degree of medical probability that actually is the case and that's what caused it, but that's a possible claim, okay? So, yep, that's exposure. All right, next one, if someone is injured on the job due to disorganization or poor systems set up by management, is the company liable? Okay, well, it's a fault-free system. So when you say disorganization or poor systems, if you're talking about, that's really broad. But I'm going to tell you is that generally, again, it's a fault-free system. So you can be 100% at fault. The employer can be 100% at fault, and it's still going to be a compensable workers' compensation claim. Okay. But I'm not really sure if I can answer, if you want to put more to it, but disorganization, no. There are emotional stress claims. Okay. So maybe this is what people are getting at is I'm really stressed out at work because my boss is an ass, I don't know. No, okay, not that. Okay, can't be situational. But I will tell you, certainly PTSD is real. 1 October happened, and I was one of many lawyers that took on some of the staff members that were working at that event, pro bono, meaning we didn't charge. That is real. Okay, and so those stress-related claims are real. And so it can be a real claim, but not something like poor systems or disorganization. Okay, any other questions? I'm just going to end with fees. Okay. Work comp, we have the standard fee. Okay. It's 1/3, but there's no fee unless we actually recover anything. So we do everything what's called on contingency. Okay. Is that we do all the work. Okay. Forecasting, there's going to be money in the case. And then it's 33 1/3%, which is a pretty much industry standard. And so, but there's nothing you don't pay anything up front. The consultation is free. If we screen it for other areas of law, all of that is free of charge. And there is no money paid out. Now, there are cases where for whatever reason, we work up the case, and if there's no recovery, meaning you go to disability, there's not a disability evaluation, there's no permanent disability evaluation, or you don't qualify for one, you get a 0%. We don't charge you for anything that we've done up to that point, but that's very rare, okay? Because we really are, my robust team really knows, and screens the cases really well that we take, so we can predict and forecast that there is going to be a rateable impairment, which is where the money actually comes from in workers' compensation. So, okay. So now we're going to do the $100 giveaway to one attendee. And we are going to pull from the list. And Sabrina May, are you here? Okay. Sabrina, we will contact you. Congratulations for the $100 gift card. Thank you for attending. And we will contact you to get you that $100 gift card. All right, all. Happy St. Patrick's Day. Remember, full service disability and injury law firm. We do it all. So there's no really other reason to go anywhere else. Thank you for coming. Bye.
Shook and Stone. Call 702 get more.